NACDL is the association of the nation's criminal defense bar.
Thank you for joining and attending this afternoon's webinar, where we'll be talking about race in the criminal legal system, race and prosecution. My name is Monica Reed. I have the pleasure of serving as Director of Advocacy here at the National Association of Criminal Defense Lawyers. We are pleased to be joined by our event co-sponsors in hosting today's webinar, which is Fair and Just Prosecution. I'm going to turn it over to Miriam Krinsky, who's their Executive Director, to give us some welcome and opening remarks.
Thanks so much, Monica, and thanks to everyone. I see we've got a wonderful group joining us, and it looks like you all are coming from parts all over the country. We are so thrilled to be partnering with NACDL on this and on other areas where we shared a common interest in looking at how can we improve for the better our criminal legal system. Fair and Just Prosecution began in early 2017 when we saw a new generation of leaders coming into office and filling that all-important role as elected prosecutors, recognizing that we needed to be doing things differently. We now work with over 70 elected prosecutors around the country, representing in excess of 1 in every 5 Americans in this nation. They come from different communities, but they come together around the belief that we need to roll back mass incarceration. We need to reject past decades of tough on crime practices. And significantly, we need to redress and we need to come to terms with decades, in fact, centuries of racial inequities that have permeated our criminal legal system. You all know, and Professor Davis's work, and I know the speakers on this program today as well will make clear and talk about the fact that racial disparities permeate every part of our criminal legal system. The statistics are well recounted. We know that Black Americans are imprisoned at roughly 6 times the rate of white Americans for similar kinds of crimes. We know that Black people make up 13% of our population, but 40% of the 2.3 million Americans who are incarcerated. And we know that these disparities come in at every point. Black and brown defendants and people are more likely to be jailed, they're more likely to be arrested, they're more likely to be detained, they're more likely to be prosecuted, they're more likely to be convicted, they're more likely to be sentenced for excessive decades-long sentences, and they are tragically more likely to receive a death sentence. Prosecutors are trusted with immense discretion. They control the front door of our criminal legal system and so much more. They can't fix everything, but they also can't use that as an excuse for inaction. They have a role to play here. They have a role to play in crafting solutions. They have a role to play in owning and talking about and recognizing and acting on what's been going on for too long. They can desist from charging crimes. They can impact police practices and reject cases that are the result of concerning police practices. They can take a second look and try to address excessive sentences that people are serving in our nation. They can reject imposition of a death penalty that is riddled with problems. And they can refuse to charge cases and end cash bail. And frankly, they can own the biases that exist in our justice system, put a bright spotlight on them, track them, and act to address them. So we look forward to the dialogue today. There is no one better than Angela Davis to walk us through this. And I'm going to turn it, Monica, back over to you with thanks again for the great work that NACDL is doing in this and other areas.
Thank you so much, Miriam. So today's webinar is kind of a part of an ongoing discussion series that we've been having on race in the criminal legal system. And it's really sought to highlight how race intersects with various issues in the criminal legal system and navigating these racial disparities and discussing ways to advocate for change. So we are definitely glad to be working with, having you guys partner with us on this today's event and discussion on race and prosecution. As Miriam mentioned, today's discussion is going to be moderated by Professor Angela J. Davis. She is a distinguished professor of law at the American University Washington College of Law. Professor Davis, among her many publications, is the author of Arbitrary Justice, The Power of the American Prosecutor, and editor of Policing the Black Man, Arrest, Prosecution, and Imprisonment. And other publications include articles and book chapters on prosecutorial discretion and racism in the criminal legal system. With that said, I'm going to turn it over to Professor Davis to further introduce the panel and to get us started.
Thank you, Monica, for that introduction. And thanks so much to everybody at the National Association of Criminal Defense Lawyers and Fair and Just Prosecution for hosting this really important discussion about one of the most serious and important issues in our criminal legal system. I truly believe we are at a point of crisis in the criminal legal system for many of the reasons that Miriam already mentioned in terms of the situation we face today, with close to 2 million people in prisons and jails, up to 7 million people on probation or parole, and with extraordinary, unwarranted racial disparities at every step of the process. Black and brown people are more likely than white people to be arrested. Once arrested, they're more likely to be convicted. Once convicted, they're more likely to face stiffer and harsher sentences. African-American men are 6 times more likely to be incarcerated than white men, and 2.5 times more likely than Latino men. And similar racial disparities exist with women as well. So we are truly in a state of crisis. Black and brown people are treated worse than their similarly situated white counterparts at every step of the process. And that's what we're talking about when we're talking about people. It is true whether we're talking about people charged with crimes or people who are victims of crimes. At the arrest stage, because of racial profiling, Black and brown people are treated worse. And this is also very true at the prosecutorial stage, which is what we're going to be talking about today. And when I say similarly situated, I mean whites who are engaged or alleged to have engaged in the same behavior as African Americans or Latinos are treated better than their Black and brown counterparts. People who have the same criminal records or lack thereof, and who are alleged to have committed or engaged in the same behavior. And the same is true with victims. Victims who have had the same or similar experiences, Black and brown people are simply treated worse. And why is that? Well, the reasons are actually very complex, right? There are these socioeconomic reasons we all know about: the connection between poverty and crime, trauma and crime, lack of healthcare and education and crime. But there are also discretionary decisions that are made by people in the criminal legal system that also contribute to these disparities. Discretionary decisions made by officials in the system. Everybody's familiar with police officers, a great deal of focus on racial profiling, and that is well-deserved attention. But police officers can only bring people to the courthouse door. It is the prosecutor who decides whether that individual stays in the system and what happens to them in the system. And when prosecutors decide to charge Black and brown people and don't charge white people who are engaged in the same behavior and have the same background, same criminal record, they are creating a racial disparity, an unfair, unwarranted racial disparity. I focus on prosecutors and actually hold them more responsible because, in my view, they are the most powerful officials in our criminal legal system. They, in essence, in my view, control the criminal legal system through their charging and plea bargaining decisions. It is the prosecutor who decides if a person is going to be charged and what they'll be charged with, and they have an incredible amount of discretion in making that decision. It is the prosecutor who decides whether a person gets a plea bargain and what that plea bargain is going to be. And again, they have a lot of discretion. Prosecutors alone make those decisions. And it's very, very easy for prosecutors to charge people because the standard is very low. It's called probable cause, more probable than not, right? Which is a much lower standard than the proof beyond a reasonable doubt required to convict a person. And for that reason, it allows prosecutors, and many prosecutors unfortunately do this, it allows them to overcharge, that is, pile on charges at the beginning. Oftentimes, even when they know they can't ultimately prove those charges at the trial stage. And why do they do that? Many of them do that because it gives them an advantage at the plea bargaining stage, right? So for example, if I'm a person who's facing 10 counts of distribution of cocaine, and each one of those counts carries 5 mandatory years in prison, I'm looking at a possible 50 years in prison. That's a lot of time. And even if I'm an innocent person or a person with a strong defense, I might accept a deal if the prosecutor comes to me and says, tell you what, I'll dismiss 9 of those mandatory minimum counts if you plead guilty to 1. Well, 1 5-year mandatory minimum sentence is a long time in prison, especially for a drug offense. But I might take that deal rather than risk getting convicted and ending up with 50 years. Going to trial is a risky business. You never know what a jury is going to do. So you can understand how sometimes even an innocent person might take the deal. And the problem compounded with that is in a lot of jurisdictions, the way the plea bargaining process works is it's really not very fair. So in some jurisdictions, you'll have a prosecutor who will come to the defense attorney and say, I'll give your guy a deal. I'll dismiss these 9 counts if he pleads guilty to the 1, but he's got to take the plea today. And the defense attorney might say, well, wait a minute, I have an ethical obligation to investigate the case, to determine whether or not my client has a defense. I can't advise him to take a plea today. And the prosecutor can say, and many of them do, too bad, take the plea today or it's off the table. So that puts the defense attorney in the untenable position of having to go to a client and advise them about a plea when they haven't even investigated the case and they're not even sure if it's the best deal for the client. But this happens. This is what passes as justice in many courts across the country every day. Now, what about racial disparities, right? Do prosecutors contribute to racial disparities in the criminal legal system? I believe that they do. I don't believe that most prosecutors, I honestly don't believe it. Maybe there are some who are intentionally doing it. I don't believe that most prosecutors are intentionally creating racial disparities. I believe most prosecutors want to do their job, want to do their jobs well, but there are many complicated ways in which their decisions oftentimes exacerbate or create these racial disparities. I don't think it's a situation where you have a prosecutor who will have 2 cases in front of them, one with a Black defendant and one with a white defendant, and they just say, okay, I'm gonna charge the Black person and not charge the white person. That doesn't happen like that. I hope not. I don't think that's the way it happens. I think it's a lot more complicated than that, right? I think there are many different reasons or ways that it can happen. One is implicit bias, which I'm sure many of you in the audience know about, right? We all suffer from implicit bias. These unconscious views that all human beings possess, right? That we're not even aware of. It's that thing when we're talking about racial implicit bias that makes, a white woman on an elevator pull her purse a little closer and move to the side when a Black man gets on that elevator. She's not even aware she's doing it because it's an unconscious thing. But I think all of us of all races suffer from implicit bias. It might be based on race, ethnicity, gender, sexual orientation, color, body size, whatever. But when we're talking about race, and if we're talking about someone who has that bias and is making decisions that impact other people's lives and are in positions of power, then it becomes, in my view, even more serious. And so prosecutors, like defense attorneys and judges and everybody else, they oftentimes suffer from implicit bias. So to give an example, let's say a prosecutor has a case in which an African-American man, let's call him Jamal, is charged with distribution of cocaine. And his overworked public defender comes to the prosecutor and says, look, Jamal doesn't have a criminal record. He doesn't have any convictions. And he, is a high school dropout. His parents are poor, but he has a drug problem and he really needs to be in a drug program. And he was really selling to feed his habit. Can we see if we can put him in a drug program? And the prosecutor's like, do you have a drug program to offer? Because I don't have one, and what am I supposed to do? And so of course, Jamal doesn't have a drug program. He can't afford that. So what does the prosecutor do? They're like, what can I do? Too bad. I'm gonna go ahead and prosecute Jamal. He ends up getting convicted. He goes away to prison, okay? Another case, prosecutor another defense attorney comes to him. He's representing Todd, a white kid who's charged with distribution of cocaine. And again, this is really hypothetical because Todd never would have been charged, let's face it, but bear with me, it's a hypo. Let's say Todd is somehow arrested for distribution of cocaine in his high school. His lawyer comes in, his parents have hired the lawyer. Lawyer may know some people in the prosecutor's office. A lot of times private criminal defense attorneys come from prosecutor's office. He may be familiar with that office. He comes in, he says to the prosecutor, look, please don't ruin Todd's life. He's college bound. He's been accepted to college. He's from a good family. And, he's never been arrested before. And he has, unfortunately, a drug problem. And that's why he was selling. But his parents have found this wonderful residential program to send him away to where he's going to get treated. He's going to get better, and he'll be there for a whole year. And if he completes that program, will you dismiss this case so that Todd's life isn't ruined? Prosecutors looks and says, wow, I used to do a few drugs myself, and somebody gave me a chance, and what would have happened? Look at me, I'm a prosecutor now. I don't want to ruin this kid's life. So yes, Todd can have the program, right? So Todd successfully completes the program. The case is dismissed. He goes on to college and maybe becomes president or something. I don't know, a senator or something. So am I saying that that's prosecutors racist? No, I am not. Am I saying Todd shouldn't have got that program? No, Todd should have gotten that program, but so should Jamal. And it's unfair. Now, is that the prosecutor's fault? I'm not saying it's their fault, but that prosecutor, through her decision, has created, in my view, an unwarranted racial disparity. Sometimes it's not even a bias, and it may be that bias played a role. Like they could see the humanity in Todd. They wanted to help Todd. They were happy to be able to help Todd. Wasn't really losing too much sleep over the fact that Jamal didn't get the program because what can they do? Like, not their problem, right? But sometimes it's even more complicated than that, because sometimes it's not even about bias. Sometimes there are race neutral factors that prosecutors take into account when they are making decisions that we all agree they should take into account. So the American Bar Association has something called standards, criminal justice standards, right? They have standards for the prosecution function, for the defense function, and also for the judicial function. And these are like guidelines that they hope that prosecutors, defense attorneys, and judges will follow as they are engaged in the work that they do. And so the standards for the prosecution function, they list factors that prosecutors should take into account when they're deciding whether to charge someone or whether to dismiss a case. And there are a number of them. One of them is the strength of the case. So for example, if the prosecutor doesn't have a very strong case, the standards say you shouldn't go forward. So why should you put the victims and the defendant and everybody through a whole trial process if your case isn't strong? You have to know that your case is strong. But then how do prosecutors decide whether a case is strong or not? One of the main things they look at is the witness, right? Their main witness. Do they have a good witness that can testify, right? So let's say I'm a prosecutor and I have a case where there's a lawyer who was robbed of her briefcase. Let's say it's a white woman. I've sent her a notice to come to my office to discuss the case. She comes in, she's articulate, she tells the story really well, she's dressed well, she's a good witness. So I think that this is going to make my case strong. I'm more likely to get a conviction because I got a good witness. So I'm going to go forward with that case, right? And so in that case, the defendant doesn't get a plea deal, and I'm going to make sure that victim gets her day in court. Maybe I have another case with a complaining witness, a victim, a Black woman whose apartment was burglarized. They stole some cash from her apartment, some stereo equipment, etc. Someone gets arrested, they're charged. The prosecutor sends a notice to that Black woman to come into the office to prepare for her trial. She comes in, she's poor. She doesn't speak the Queen's English. She's not well dressed. She doesn't articulate, a really good, tell a good story. And the prosecutor's like, oh, I'm gonna have to really work hard with her. I don't think the jury's gonna find her convincing. So maybe I'll give this defendant a deal, right? And so that defendant gets a deal, right? And this victim's case doesn't go to court. So victims treated differently, right? Based on race. Was it intentional or even conscious? No. And actually, the prosecutor was following one of the ABA standards, right? And it just worked out that way. It had a racial impact. Oh, and by the way, maybe that Black woman victim doesn't even show up for the conference because maybe she has a counter job, unlike the white lawyer who's a partner who can go to work whenever they want to or not. Maybe the Black woman has a job where she has to actually show up, and if she misses a day's work, she might lose that job, certainly going to lose her pay. So maybe she doesn't show up for that reason, or maybe she doesn't show up because she's like, wait a minute, this is the same prosecutor's office that prosecuted my son, and I don't know how I feel about going down there. I'm a little nervous. I don't think I'm going to show up. Again, is this the prosecutor's fault? No, but the prosecutor made these decisions, and so they are, in my view, responsible. So here's the thing. I mean, I'm not a particularly religious person, but there's a Bible verse that I really like, and it says, to whom much is given, much is expected, much is required, right? And that's how I see prosecutors. You have all this power, you have all this discretion, so much is expected of you. Your job, according to the United States Supreme Court, is not to seek convictions. It's a case called Berger versus United States, where, and I'm paraphrasing a bit, the Supreme Court says it's not the duty of the prosecutor to seek convictions. It is the duty of the prosecutor to seek justice, right? Justice. And what does justice mean? Like, justice may mean seeking a conviction in some cases, but in some cases, it may also mean dismissing a case, right? The prosecutor represents the community, right? They don't represent the victim, they represent the entire community, and that community includes the victim, excuse me. It includes the rest of us in the community, and it also includes the defendant. And so the prosecutor is supposed to make a decision that is just and fair for everybody. Big job, isn't it? And it's really hard and it's really complicated, but I believe that prosecutors have that responsibility. I also believe they have an ethical responsibility to seek racial justice. I wrote an article about that, the prosecutor's ethical duty to seek, to end mass incarceration, in fact. The model rules of professional responsibility, they apply to all lawyers. Model Rule 3.8 applies to prosecutors specifically. And Model Rule 3.8, and if I can just quote it very quickly. Give me 1 second here, sorry. The comment to Rule 3.8 says a prosecutor has a responsibility of a minister of justice and not simply that of an advocate. And in the standards for the prosecution function, it says the primary duty of the prosecutor is to seek justice within the bounds of the law, not merely to convict, which mirrors the language in Berger. There's more language that goes on to say the prosecutor should seek to reform and improve the administration of criminal justice. And when inadequacies or injustices in the substantive or procedural law come to the prosecutor's attention, the prosecutors should stimulate and support efforts for remedial action. And I can think of no greater inadequacy or injustice than mass incarceration and unwarranted racial disparities. And at this time, I'll say one little last thing before I turn to Wes, and that is, accountability, right? I've talked a lot about responsibilities, but we need to hold prosecutors accountable. And the way we do that is is through the ballot box, right? Because a vast majority of state and local prosecutors, and by the way, 90% of all criminal cases are handled on the state and local level, are elected officials that run for office. And you need to pay attention to district attorney races and hold them accountable. To end mass incarceration and to end, or at least reduce, hopefully totally end these awful racial disparities. So Wes, I'm going to turn to you now. Wes Caines, who is at the Bronx Defenders. I didn't realize I was supposed to introduce you all, and I'm going to introduce you afterwards when I get on, because I want to adequately introduce you and Akai. But I'm going to turn to you now and just have you respond, and I'll do an intro on the back end, which is a little different. But I'd love for you, if you would, to address this. Like, I can imagine a lot of prosecutors who hear what I just said and say, you know, that's all well and good. We know that there are all these injustices in the legal system, but they're caused by problems that are beyond my control. What would you say to a prosecutor who responded that way? And whatever other thoughts you have about what you think are the prosecutor's responsibilities.
Thank you. No need for an introduction on my part. Totally okay with just Wes. First, I want to thank the NACDL for this invitation and this opportunity really to have a discussion around these issues. I think, unfortunately, they are quite timely now, and they have been quite timely for some time. But to respond to your question about what a prosecutor would claim as their responsibility as they seek to dispense justice, I would say we have the power we claim, and that context matters in all instances, right? And you know, for a prosecutor, I would say to any prosecutor trying to seek justice in the midst of other institutional and systemic failures by criminalizing and incarcerating, that they are on a Sisyphean quest. It is simply not possible. While I understand the enormity of the task, and you know, before I continue, let me just say, you started by speaking to the complexity and challenges of, you know, the system and how it operates in such racialized ways. And I want to echo that. I want to acknowledge that, because I think that I wouldn't want anyone to walk away from our discussion thinking that any one of us, especially myself, is making an argument that these are very easy questions to answer and practices to curtail and adjust or eliminate. They're not. They're going to take a lot of courage. They're going to take a lot of commitment. So I just want to acknowledge that. And it will definitely take more than prosecutors to right our skewed social order. However, for prosecutors to operate in a vacuum as if other systems do not feed our criminal legal system is a disservice to their duties. Over the past year, we have heard many calls to defund police departments across this country and to invest in communities. Those calls were often met by systems actors like prosecutors who argued that this was wrong-headed. However, over the past several decades, and I want to stress decades, generations, there have been a systematic defunding of schools, open spaces, libraries, after-school activities, and a whole host of other resource allocations that were stripped from poor Black and brown and poor communities, right? And there have been so much as a whisper from these same systems actors in arguing for reinvestment in communities in a way that can actually drive public safety, that can actually drive thriving communities. So when prosecutors say, you know, this is just something that is outside of my purview, I would argue actually it's not. As a public servant, prosecutors have a platform, and it's a platform that I argue that far too few of them utilizes to call attention to the disparities in our societies and many of our communities. You very rarely hear a prosecutor, unless there is some very hot event that has taken place, speaks out about policing practices, for example, right? And we know that policing practices directly impact prosecutors and the decisions that they have their discretions to make. But there's silence. You very rarely hear prosecutors argue at budget time that there should be an increase in budget in school and after school activity, or even make an argument for their own divestment instead of hiring a new prosecutorial class to come into the office to prosecute cases. Say, you know what, we have enough prosecutors, our attrition rate is not that high. We will forego that funding, place that funding into the community, allow communities to guide how it is resources are allocated for their own thriving and safety. We don't hear those arguments from prosecutors. And I would argue that, you know, this is part of their duties and responsibility as public servants. But I also want to drill down a little bit on this idea of, you know, prosecutors being the gatekeepers, and they're the gatekeepers after police brings defendants or those accused to the court's doors, and that is the discretion of the prosecutors to let them in. I think a prosecutor has power before then. I think a prosecutor has power to say to police departments in their jurisdiction, practices and policies that are targeting Black and brown and poor people will not be honored by their offices. And I think they need to say that loudly to police departments in private. And I think they also need to say that loudly in public, so that the public understand the duty of the prosecutor, to your point of Berger, is not about convictions and incarceration, but it literally is a space that allows for justice to happen in a community. That's very important. I've got two additional points, and one of which I have to admit, I'm new to this position. And for many years, my somewhat libertarian leaning self have argued against the notion of term limits, because I felt that, you know, people have a civic responsibility to be engaged and to let their voices be heard through our, you know, ballot process, and that it wasn't necessary to have a statute that limits any particular candidate's time in office. I have since come to realize that there is so much trauma in certain communities, and I'll speak specifically to where I'm located in the Bronx, New York, that our electorate responds at election time at less than 50% of eligible voters, historically and perpetually, right? And some may argue, as I often had in the past, that, well, that's their problem. They don't leverage their voice and their vote, then the policies that impact them impacts them, and they had an opportunity. See you in 4 years. But in critiquing myself and my ideas, I've come to realize that that doesn't take into context, again, that there's a lot of community trauma, and that there's a historic experience that a lot of communities have of being civically engaged, electing people to offices who promised a lot and delivered a little. And that over time, this has eroded the trust that many communities have in our electoral process. And, you know, I've changed my mind. Like, if the president of the United States is term limited by 8 years, I think any other elected position in this country ought to be term limited as well. I just think until we have a more equitable society, to ask people who have been traumatized and alienated and marginalized by our electorate to participate in that process to change it is just a hill too high to really climb. And lastly, I want to acknowledge that we are a week away from the Attica Rebellion in the early 70s. And for almost half a century now, we have had an opportunity to address a lot of really inhumane conditions within our prisons and jails, and we have not done so. And if Attica is a reminder to any of us, at least those of us who remembers it, it's a reminder that literally the things that the men in Attica was arguing and fighting and died for, along with state employees who were murdered by their own state government, still exists today. We have conditions right now in many of our state prisons and local jails. And I want to highlight the atrocities at Rikers Island, the deaths at Rikers Island that are taking place in 2021 in the wealthiest state in this country, in the wealthiest city in this country, and that we are all allowing this to happen. And we have not all called on our city government to do something beyond having press conferences and acknowledging that there are difficulties and challenges, I think really is an affront to the legal profession and to American society. This is unbelievable to me that we have chosen to place people in cages, and then after placing them in cages, we cannot even protect their humanity or their lives. That's a problem. Thank you.
Wes, thank you so much for those really thoughtful and compelling remarks. I greatly appreciate it. And now I'm going to give you an outro because I didn't give you an intro, so it's going to have to be an outro and tell people who this wonderful man is. Wes Keynes, forgive me for reading, but I want to get it right. Wes Keynes is a graduate of Bard College and New York Theological Seminary. He is the chief of staff at the Bronx Defenders. And as chief of staff, he spearheads the organization's systemic reform efforts, which include overseeing the policy, impact litigation, strategic communications, and community organizing teams. Prior to his current role, he was director of reentry and community engagement, roles which allowed him to work closely with directly impacted communities and understanding and developing strategies to overcome barriers that perpetually punish those ensnared in government systems. Before joining the Bronx Defenders, he worked at the Brooklyn Defender Services and launched the Records Accuracy Project, which utilized local area law students to identify and correct records of arrest and prosecution sheet errors. To date, he's trained nearly 50 law students in the complex world of reentry and reentry policy work. He sits on the board of the New York Civil Liberties Union, the Correctional Association of New York, Inside Change, Brooklyn Community Bail Fund, and Newark Support Services. He's a member of the New York City Bar, and his life goal is the empowerment of underserved and marginalized communities as they become creative self-advocates who challenge policymakers' notion of the social contract. And we certainly saw that in his remarks today, so thank you, Wes. So Akai, I want to turn to you, and I'm actually going to introduce you first. Akai Johnson is the Deputy Director of the Reshaping Prosecution Program at the Beer Institute of Justice. He leads a team that works with elected prosecutors across the country to end mass incarceration, address racial disparities, and make their offices more accountable to the communities that they serve. He joined VERA in January of 2019 after serving for 5 years and as an assistant U.S. attorney in Washington, D.C., where he handled both local and federal crimes and tried more than 40 cases. He volunteered with community-based prosecution programs designed to build positive relationships between citizens and law enforcement, and taught a gender-based violence course in Indonesia for Pakistani prosecutors and police officers. Before joining the U.S. Attorney's Office, he clerked on the D.C. Superior Court and worked as a litigation associate at Jones Day. He's a graduate of Georgetown Law School and the University of Southern California. So Akai, and I want to tell everybody, I've worked with both of these men, and I think they are phenomenal people and both heroes of mine. So I'm really honored to be on this panel with both of them. So Akai, I'm going to turn to you. Like, this is what you do every day. So I would like you to talk about why it is so important for prosecutors to work to end racial disparities. And can you tell them how can they do it? Like I present all these complicated things. It's not, they cause them, it's unintentional. What can they do in their ordinary practice to try to end these disparities?
Yeah, appreciate that, Professor Davis, and hey, everybody. Before I get into that, I just have to side-eye a little bit Professor Davis saying I'm a hero of hers. That seems preposterous to me on a number of different counts. Professor Davis has been studying these issues for longer than I've been a lawyer, I think. So hard for me to say.
Old people can learn from young people, and any old person who doesn't think that, they have a problem.
I'm not calling Professor Davis old, for the record. I just want that to be clear in this webinar too. But to your question, so prosecutors definitely have a responsibility to address systemic racial disparities. And I think that stems from two reasons primarily. One, it's who you represent, and two, it's what you represent. I remember, as Professor Davis noted, I was a prosecutor at DC, and getting that phone call that I got the job and I was on the Metro, our version of the subway in DC. And you just have this moment where you look around the train and you stop and think, oh, I'm going to represent all of these people. Like, this is the community I'm going to represent. And you're in court, and because it's DC, you can say, Akai Johnson for the United States. You can say Akai Johnson for the people. And you can try to say Akai Johnson for the district, though district residents will definitely side-eye that because the district doesn't have the kind of representation that other places do. But in any event, you have this incredible power and it feels like such an honor. And one thing I grew to appreciate in my time as a prosecutor is I didn't really represent everybody who was on the Metro that day. I didn't really represent everybody who was in the District of Columbia, because there are a lot of people in DC who couldn't tell you where the courthouse is, who have never been to the jail, who the system never appreciably impacts their lives. And then there's a whole separate group of folks in DC who interact with the system on a dang near daily basis. And one story that always stood out for me is I was in the hallway in court, and there was this 8-year-old just kind of strolling down the hallway by himself, which was strange in and of itself. And then I see him stop this gentleman, probably in his 40s or so. And he says, "Yo, Unc, I thought you guys stepped back. I didn't know you were out." And in DC, step back means you literally get walked to this door behind the judge, and that door leads to a cell. That's kind of slang and shorthand that only people who are intimately familiar with the justice system in DC would know. And that this 8-year-old had the verbiage to say that, and then also was surprised to see who may have been his uncle, who may not have been his uncle, was out, just speaks to how deeply embedded the system is in his life at his age. And so, and in terms of addressing racial disparities, as a prosecutor, you represent the people most impacted by the system. And in too many places across the United States, those people are Black, brown, and broke folks. And so you definitely have a responsibility to be accountable to them. And that's one reason you have a responsibility to address racial disparities. I think the second reason beyond who you represent is what you represent. Professor Davis and both Wes have referenced prosecutors as being these ministers of justice. And if you're a prosecutor, among a lot of other things, you should certainly be concerned with justice and safety. And I don't know how you can be concerned about those two things and not care about systemic racial inequities. As both Professor Davis and Wes have referenced, there are all these injustices in our society. We live in a broken and fundamentally flawed society in so many ways. And those fundamental flaws and injustices are reflected in our purported justice system. So if you're tasked with pursuing justice, pursuing safety, you have a responsibility to look at the kind of issues that Wes referenced, like, why is it that certain people are disproportionately represented in our jail? Why is it that people are disproportionately killed in our city? Why is it that certain people don't feel the same kind of safety that others do in our city? And bringing it home for me as prosecutor in DC, I would see the disparities in court every day. I could probably count on two hands the number of non-Black people that I prosecuted while I was prosecutor in DC. And one of my biggest regrets as a prosecutor is never really stopping to reflect on why those disparities exist, right? Everybody sees them, everyone's aware of them, but I never stopped to reflect, well, why is it that 99% of homicide suspects in DC are Black? Why is it that 97% of people sentenced to prison from DC are Black? And when you stop and reflect on those issues, you start to unpeel this onion and get at a lot of the systemic disparities like redlining, our country's history of oppression, that explain the disparities that you see in court. But as a prosecutor, you can't even begin to address those things until you're willing to acknowledge how we got here. And so just from a standpoint of justice and safety, you have to be willing to look at who's disproportionately impacted by the system and be willing to do something about it. And as Professor Davis mentioned, that what do you do about it is really hard. It can be incredibly difficult. And thanks to folks like Professor Davis and Wes, our team came up with Motion for Justice, which is a website that lists concrete steps that prosecutors can take to address these kind of systemic disparities. And when I'm saying systemic disparities, it's helpful for me to think of an analogy of a driver and a car. So I drive a 2010 pretty beat up Toyota Prius that my wife has been saying we need to trade in for a while. But if you put me in a brand new Porsche, I'm gonna dust the best race car driver who's driving my car any day of the week. Not because I'm a good driver, because I'm using better machinery. And so when it comes to addressing systemic disparities, we've got to look beyond just the driver, because that's important too, but we've also got to be willing to question the machinery, the systems within which we operate. And Motion for Justice, again, huge shout out to Wes and Professor Davis for going through what felt like a year process to come up with this guidance. That's what that is. It's a resource, but just concrete things that prosecutors can take. And so I'll highlight 4 of those things now. 2 of them, I would say, are more office-wide things that prosecutor offices can do. And then 2 of them, I would say, you're an individual prosecutor, you could do these things tomorrow. So one thing that prosecutors could do is stop taking cases based on pretextual stops or non-public safety stops, as they're also called. I'll shout out John Choi in Ramsey County, Minnesota, the same jurisdiction where Philando Castile was killed because he got pulled over for allegedly one of his taillights was out, and that led to his death. John Choi has taken the step, as Wes noted, of moving beyond his charging authority and telling police officers, we're not going to condone this anymore. It's not acceptable that you disproportionately stop Black and brown people and poor people and bring them to our doorstep and expect us to just charge the cases without considering how that undermines trust in the community, how it undermines safety. So one thing officers can do is just say, we're going to treat pretextual stops or non-public safety stops, i.e. those where someone gets pulled over for a dark window tint, air freshener hanging from their rear view mirror. We're going to treat those as Fourth Amendment violations, and we're just not taking those cases. I also want to commend the county attorney, John Choi, for going a step further. He also said, we're not going to take cases where the only legal basis for a search is consent. So if an officer pulls up to a car, even if they stop them for reckless driving and someone was actually in danger, if the only basis to search the car is consent, they're not taking that case because consent searches disproportionately impact Black, brown, and poor folks. So that's one example of something an office can do differently. The second thing relates to some of the factors that Professor Davis mentioned. There are these so-called neutral things that prosecutors rely on day in and day out, but they have this disparate impact. And one of those things is criminal history. We know that Black and brown people are disproportionately likely to be arrested and charged and brought into the system. I'm mindful, and I saw folks in the chat in the Northwest, I grew up in Portland, Oregon. There was an area of our city where if you had a house party and a bunch of kids were drunk and they were underage, the police would come, tell them, get out of here, go home, and that would be the end of it. If you lived in a different area of the city and there was a house party, the police came, they were either giving tickets to everyone or arresting everybody in the house, no questions asked. That incident alone reflects who has a criminal history, who doesn't. And I think one of the hard things for prosecutors to realize is criminal history is not a reflection of all the bad things you've done in your life. It is a reflection of when the police have arrested you and brought you into the system. So one concrete way prosecutors can move away from looking at a so-called neutral factor of making decisions is don't consider criminal history in diversion decisions. If someone should be diverted from the system, they should be diverted. It shouldn't depend on what their criminal history is because that's racially disparate. So if there's someone with a substance abuse issue and they've committed a couple armed robberies in the past, well, the issue right now is the substance abuse issue. It's not the armed robberies. So they should be diverted away from the system. So I would say declining non-public safety stop cases, not considering diversion in criminal history, and diversion decisions are two things offices can do. Now, let me turn to the individual prosecutor who says, you know what, I'm not in this reform-minded office. There's no way my DA would do those kind of things. Well, one thing you can do, which Wes hit on and Professor Davis hit on, is just see the dignity in the people you prosecute. I think one of the byproducts of our system that's built on a structure of oppression is the dehumanization of people who come into contact with it. And so one concrete thing you can do is just stop calling people defendant in court. Stop calling them defendant in briefs, just say their name. I remember being in law school in a legal research and writing class, and my professor said, which I'm sure was the same version of a speech a lot of y'all got, if you're a prosecutor, always refer to the person as defendant, because that dehumanizes the person for the jury. It makes it easier for the jury or judge to pass judgment on them. But if you're a defense attorney, always say your client's name, because you always want to be reminding the judge or jury about their humanity. If you're a prosecutor, you shouldn't have to rely on a tactic that dehumanizes someone to get a conviction. So say their name, recognize their humanity. It may seem like a small step, but it's a meaningful one. And closely tied and building off of that, by recognizing someone's dignity, it also means learning why they came into the system in the first place. Brian Stevenson famously says, everyone is more than the worst thing they've ever done. But if you're a prosecutor, that's frequently the only lens with which you see someone. You see the police report, you see the criminal history, and you never really get to know what brings someone into the system. So I would say work closely with public defenders to learn what brought their client to this point. Because none of these crimes or incidents happen in a vacuum. There's always a broader context to it. And I think by learning that context, you can also make better decisions about what is most appropriate to ensure this doesn't happen again. Because incarceration exacerbates a number of the things that create violence in communities. I mean, research shows that there are 4 things that drive incarceration, that drive violence: exposure to violence, isolation, shame, and an inability to meet your own economic needs. Well, unfortunately, incarceration exacerbates each one of those things. And so by learning what drives people into the system, you can more critically reflect, how is incarceration going to make us safer? What are the alternatives here? What does a survivor actually need to feel whole and heal? And so making incarceration a last resort as an individual prosecutor is another way that you can start to combat some of these racial inequities, because you start to see the humanity in the people you prosecute. So those things are not easy. And I don't know if you can see the book over my shoulder, but I'm a big fan of Robert Kennedy. And one of the things he likes to say about change is that you need 3 things to have meaningful results and see this kind of wave of reform and change. You need passion, you need vision, and you need courage. Passion is to care enough about an issue to want to be involved. Vision is to know what to do about it. And courage is to have the boldness to do something different about it. If you're on this call, I think there's probably no question that you have the passion. If you're looking for steps to take, Motion for Justice is a great place to start, but also talking to amazing folks like Wes and Professor Davis is probably a better place to start than that. But then you really need that courage. And that's the thing I would encourage folks to lean into. Really be bold, because it's going to take courage to change the status quo. I think we have this rosy image of people in the civil rights era that everything was all great and, everyone was for them and they did all these monumental things without any pushback. But that just wasn't the case. They were vilified for trying to do things that we look back on now that seem so basic. And I think we're in the same space now. So even little things, you'll get a ton of pushback, but you have to have the courage to push through if we want to have a society that's better for generations down the line. Because my hope is one day people will look back, maybe 2 generations of lawyers from now, hopefully much sooner than that, and they'll say, police used to stop people for having air fresheners from their windows. That's crazy. Why would we ever do that? But we're only going to get to that point if you're willing to be courageous today. So my hope is that people will be able to demonstrate that courage, and so thankful to be part of the conversation today.
Thank you so much, Kai. And I think everybody now realizes why I say, yes, you and Wes are my heroes for sure. The work that Vera is doing is just absolutely phenomenal. I was honored to help and participate with it. I also just want to shout out and highlight the great work of Fair and Just Prosecution, which has just done a great job of not only bringing all these prosecutors together who are trying to do the right thing, but of educating the public, the country, about the great work that they are doing and highlighting it in the media all over the country. And that's so incredibly important. So thank you, Miriam, for all the work that you and your team do every day. Before we go to the Q&A, and we do have some questions there and I want to start them, I want to give us a chance, if you all want to ask questions of each other or comment on each other. I want to start out just making one point, which is neither here nor there, but I feel like I have to make it because when I was giving my examples, I would say, oh, this one's white, this one's black. Just to be clear, you know, Black prosecutors who are in these offices who are not trying to transform the system make really bad decisions too that exacerbate the problem. So my book, Arbitrary Justice, that I wrote a long time ago, I tell real life stories about some of the prosecutors that I dealt with in the U.S. Attorney's Office where Akai used to work. Of course, that was before Akai was born, but same office. And I can tell you that a lot of the examples, and as I'm thinking about it, the examples I gave more of them involve Black assistant U.S. attorneys than white, where they were making these awful decisions that had racial impacts. I do think it's incredibly important that we diversify the prosecution function because a tiny percentage, and Miriam, you may have the number, a tiny percentage of chief prosecutors are actually people of color or Black or brown, a small percentage. And so we do need to change that because of course we need to diversify, but don't think that automatically because somebody is a Black chief prosecutor that they're about doing the right thing. Because I could, but I won't give you many examples to prove that that's not the case. We're talking about people who, regardless of their race or ethnicity or gender, really want to use their power and discretion to make change. And that comes in people of all races, genders, sexual orientations, everybody. So, and you just lifted up John Choi, who's one of them, an Asian American who is doing the right thing in that regard. So I just want to give you all a chance if you have any other comments for each other, you know, before I move to the questions we have in the Q&A. And don't feel compelled if you don't force yourself, but I do want to give you that opportunity.
No, I sorry, go ahead.
Go ahead. So I just wanted to build off of one of the points that was made in passing, and I think it's also threaded into a question that's in the chat that we might get to, and that is how important it is to not even allow the front door to the criminal legal system to get open. Because once it gets open, once we're on that pathway, and in so many instances, we end up on that pathway because individuals are struggling with mental health issues or substance use issues or poverty or so much more that's just simply not addressed through the criminal legal system. We shouldn't have to criminalize people. We shouldn't have to throw them behind bars to give them help, to give them treatment, to deal with the underlying problem. But once we open that door, even a crack, inevitably bias and disparity is going to creep through that front door along with it. And so, you know, I often talk about how important it is for the criminal legal system, first and foremost, to just do no harm, which means even if we don't have alternative pathways built out, this system just needs to get out of the way. And I do think that touches on, again, I think the issue that came up in the question of diversion versus deflection. I think what we should be striving for in so many of these instances is just deflect, is getting prosecutors to stand up and do what a number of them are doing in increasing volume, which is to say, we are simply not going to prosecute. We're not going to take, you know, the first step on these things. It's not that we'll bring them in and divert, but we just need to close that front door down. And I think that inevitably is going to have an impact on policing practices and not get us into the slippery slope and all of the failures that come along with the criminal legal system.
I mean, so obviously and great point, Miriam, I'm obviously on that team, but I guess maybe to play devil's advocate a little bit, like what do y'all say to folks? And I'm sure a lot of the public defenders on the line and maybe some of the prosecutors will say this too, you know, well, the legislature passes the law, they pass the crimes. How can I, as a prosecutor, decide to just decline these cases? Like, how do y'all think folks should respond to that?
And so thank you for raising that, because that is often the retort that that we hear. You know, many who are wedded to an old way of doing things will say, but it's the law. You know, if Chesa Boudin or Rachel Rollins or Larry Krasner or Kim Fox or a host of others want to just say no, go run for the legislature and say no there and change the law. You know, I think that's absolutely wrong, because it fails to recognize, and all of the things, Angela, that you cited in the ABA standards and elsewhere recognize this. Prosecutors have discretion. They have always had discretion. There's simply not the resources to prosecute every crime on the books. Discretion inevitably creeps in. And for decades, prosecutors have had guidelines that say, what are we going to turn down and what are we going to accept? I mean, there have been parts of the country where adultery is still on the books as a crime, where interracial marriage is still on the books as a crime, where abortion is on the books in increasing numbers, sadly, as a crime. And you know what? It's the role of elected prosecutors to say, I am not going to do that. That is not in the interest of my community. The community elected me. And if the community disagrees with the choices I make, I mean, elected prosecutors should be very transparent about what they're doing, not hide the ball, you know, say the way Rachel Rollins did during her campaign, here is what I will not prosecute. If the community doesn't like that, then the community can make a different choice in the next election.
And can I just add, there's a long line of Supreme Court cases that, believe me, don't get me started because we need to get to the Q&A, where the United States Supreme Court has affirmed and uplifted and confirmed the discretion of prosecutors to dismiss cases as they see fit, to charge as they see fit. Ironically, those cases were all cases where people were challenging the discretion of prosecutors because they had used their discretion in ways that created racial disparities. We're talking about selective prosecution cases, right? Armstrong versus United States, McCleskey versus Kemp, where people were saying, wait a minute, the prosecutor did this and it caused racial disparities. The Supreme Court said, too bad, they have power, they have discretion, and we're upholding it. It's not until the prosecutors are trying to use that same discretion and power to transform the system and fix the problems that all of a sudden people are saying, wait a minute now, you can't use your discretion, you got to do what the legislature says. So it's crazy. Prosecutors have been dismissing and declining cases since there were the prosecutors ever existed in this country, as Miriam pointed out, these laws that are on the books that they ignore. So that is here. So let me start with this one, and I think we can all answer pretty quickly. Are prosecutors under pressure to convict as many cases as possible, or do they have to meet a quota of processing X number of cases in a certain time period? It just seems like prosecutors want to get as many convictions as possible instead of looking to establish or direct folks to diversion programs. I mean, I'll answer it and people can add if they want to. That's the traditional model. I don't know about quota or specific number, but success traditionally in prosecutors' offices was measured by convictions, like how many people you can convict. That needs to change. Success needs to be measured by how many cases can you get out of the system? How many people can you divert out of the system? How many people can you help in this system? And so I think that is beginning to happen with this growing number of reform-minded prosecutors, progressive prosecutors, people have different names for them. It's beginning to change, but that number needs to grow, because though that number is relatively small compared to the number of district attorneys, state's attorneys, county attorneys, they go by different names across the country. They are close to, I don't know, 2,500 up to 3,000 of them that are elected. And so we need, that number needs to grow, but with traditional offices, that has been the case. And I think that needs to change. Let me ask this question, because I think it's just so important. For any panelists, can you speak to the impact of racial disparities in the prosecution of juveniles? Can anybody talk about that issue, and specifically, like, what can prosecutors do to change that when it comes to juveniles? Because we know, like, Black and brown boys in particular, but quite frankly, youth, are like, they're really the victims of, you know, harsh treatment in the system, being charged as adults, being vilified. And I have to give a shout out now to Kristen Henning, who has an amazing book coming out called The Rage of Innocence. That's coming out in a couple, if you haven't read The Rage of Innocence, and I hope somebody will put the link in the chat, it addresses this issue in such a powerful way, and that book is about to come out. But can anybody address, like, what can prosecutors do when it comes to the issue of juveniles, Black and brown juveniles in the system?
I think one thing that prosecutors can do is to not prosecute children as adults, not place them in adult systems, and expect them to have adult accountability when the science is clear around mental and emotional development happening way into one's 20s. I think that we have a cultural dynamic where young Black boys and girls are not recognized in their youth as youth, right? There's this sense that they're just short, small Black people, and they're treated as such. And I think until we start to recognize that children are children, Black children as well, and treat them accordingly, young people who are still learning and growing and will make mistakes. And some of those mistakes may be very impactful mistakes that impact people's lives, right? But we still can't throw children out when those mistakes happen. We need to find ways to really have pathways of growth and maturity, even for those of our young children who are. So I would just say, stop charging children as adults.
I mean, that it fundamentally, let's just recognize kids are kids. And in our 21 Principles document, we've really encouraged prosecutors to recognize that, but also realize that what we know from brain science makes clear that it doesn't stop at 18. We need to be acknowledging that the brain continues to develop until age 25. And other countries have embraced the view that young people should not be put into an adult system up to those ages into their 20s. So, we need to stop charging them in the adult system. We need to stop putting them in adult facilities. We need to recognize the potential for change and take a second look at young people who did receive those kind of sentences and are serving them out today, pose absolutely no risk to the community and deserve an opportunity to come home. So we also need to fix past problems, even as we're trying to address future changes and reform.
Okay, great, thank you. I'm gonna go to another question. To any panelists, can you speak to the efforts of Chesa Boudin in San Francisco and other progressive DAs, such as eliminating cash bail and especially diversion programs? Can they implement more restorative justice programs or just divert? Do you agree with their focus? Does anybody want to jump in? I can jump in, but I'm going to defer first to others if you want to jump in.
So I can take at least part of it. So they can pursue more restorative justice programming. I think though, and I have to admit, I'm not as familiar if Chesa is doing restorative justice work, but I will shout out Dinah Beckton in the Bay Area. She works closely with Impact Justice, a community-based organization to do restorative justice work. I think if DAs are going to do restorative justice work, they should try to do it in partnership with communities. I think Wes has already touched on the need for greater investment in places where there's been disinvestment for so long. And part of the long-term solution to safety is, people closest to the problem are closest to the solution. People know what they need to be safe. And so for prosecutors, I think it's important to work with those most impacted by their decisions and to try to set up structures and apparatuses that live in the community so we can start building alternatives to the system we currently have.
Yeah, and I just want to say too, I think there's a lot of controversy around the notion of progressive prosecutor. I think there are a lot of people in the defense community who are a little bit wary of it, and I get it. I'm a former public defender myself. I was at PDS in DC for 25 years, I get it. I never thought in a million years I'd be working with prosecutors. I mean, I still what's going on here? I mean, I spent 25 years cussing out prosecutors for all the terrible things they do. And I still cuss out the ones who do terrible things. But now I'm working with those who really want to change. And some of them are former defenders, public defenders, believe it or not. But this whole notion of progressive prosecutor has now become very trendy. And so I think there are a lot of people who want to call themselves progressive prosecutors because it's the thing now. And everybody who's calling themselves progressive prosecutors, they're not. And so you really have to look to what folks are doing. And there are all kinds of things they can do at every step of the process. I don't think that there's a litmus test. I don't think there's a formula because, you know, Scott Colomb in Columbus, Mississippi can't do the same things that Larry Krasner is doing in Philadelphia because he's in Columbus, Mississippi. But I think that as long as they are doing everything they can do in the communities where they are, where it's feasible for them to do it, to try to lower the prison and jail population and end the racial disparities and end cash bail and end the use of cash bail and create meaningful conviction integrity units and sentencing review units and not seek the death penalty and not charge juveniles as adults. All those things, have open discovery, turn over everything. If they can do all those things in their jurisdictions, it's going to look different in different places. They deserve the support in doing that because in doing that, they are getting more folks out of prison and jail. And I'm talking to my defendant friends out there, right? I mean, I look at Kim Fox, who had oversaw the first mass exoneration in the state of Illinois, where she, you know, released all of these wrongfully convicted people, publicly apologized to them. And if you talk to them, they will tell you, I like what she's doing, right? So I think that you have to really like examine them, educate yourself about the work they're doing. I think Miriam's group, Fair and Just Prosecution, does a good job of putting out there all the good work that they are doing. I think, you know, Akai at Vera, I think they're doing like the most meaningful work out there in terms of training folks and lifting up what they're doing. So I think pay attention to that. And I think those who are doing the good work deserve the support and need the support because believe you me, the folks who want to uphold the status quo are coming after them every single day. And so if you like what they're doing, you should support what they're doing and communicate with them. So I'll stop there in case someone else wants to weigh in on that. And if not, I can go to another question. Let's see. Well, I'm going to turn this one to Akai. They're directing it to me, but it goes to you. How do you suggest or recommend that DC residents hold their adult prosecutors accountable given home rule limitations? And I saw that somebody in the chat gave a shout out to Carl Racine, who is the elected Attorney General, and he actually handles the juvenile cases. And I tell you, Carl Racine, who's also a former public defender from the DC Public Defender Service, I have to give that shout out, is doing remarkable work in his office in terms of transforming the legal system in the cases that he has jurisdiction over. But Kai, let me let you respond to that question more generally.
Yeah, I mean, that's the age-old dilemma for folks in the district, right? Taxation without representation. So I think probably the most direct way, I would say two strategies to hold the DC prosecutor accountable. And for folks who may not be aware, because DC is not a state, the federal prosecutor here handles both local and federal crime. So they basically serve the function of a local DA's office, but the DA is not elected. He's appointed by the president. And depending on the on your political leanings or the administration, that could be a good thing or bad thing for people in the district. So I think there are two ways. One is legislatively. I saw someone put in the chat, the DC Council can really just limit the discretion that the US Attorney's Office has. I think the example in the chat around changing the definition of child within the statute is one way to do that, because the DC US Attorney's Office only has jurisdiction over adult cases. By increasing the age at which you define child, you can take cases and people and put them in Carl Racine's office, who's doing amazing, wonderful things. And they actually have an amazing restorative justice program. It doesn't always get a lot of attention, but they're doing amazing work in addition to some gun violence prevention work that's outstanding in DC. The second thing I would say is just public pressure. Even if they're not elected, they are very sensitive to what's covered in the media and what's covered in the press. And so if there's a lot of public pressure on them to stop doing something and to change their ways, I think they are receptive to that. I know like no prosecutor wants to be in the paper, as just a general rule of thumb. And so if you can build that kind of political pressure through community organizing in other ways, I think that's another way to hold them accountable. But unfortunately, until DC is a state or the laws changed, there isn't a direct electoral way to hold the DC U.S. Attorney's Office accountable.
So I want to turn to this another question here that I think is interesting. It's a big issue, I think, in a lot of prosecutor offices, particularly those who are trying to change and do things differently. And the question is this: some prosecutors and prosecuting agencies are under pressure from law enforcement agencies. Not prosecuting a case can expose a prosecutor or prosecution agency to retaliation from law enforcement officers and law enforcement agencies. And political pressure applied by those in and dependent on the law enforcement industry also plays a role on prosecuting decisions by elected prosecutors. Is there something of a mutually reinforcing protection racket? I don't know about the last part of that, but this is, I think, a huge issue where you've got particularly these reform-minded prosecutors coming in and saying, I'm not going to charge these, I'm going to decline these low-level offenses. And, police departments, and particularly very powerful police unions, are furious and they like going after the prosecutors. But of course, prosecutors have to rely on police officers like as their investigators. And it creates a problem. So I want to know if anybody here wants to address that issue. It's certainly an ongoing issue in a number of these offices with prosecutors who are really trying to do the right thing.
I'm happy to grab that, Angela, because it's definitely something we've seen. I mean, we've seen it in Chicago. We've seen it. It was playing out in other parts of the country as well, in St. Louis with Kim Gardner. And the landscape was a lot more challenging over the past 4 years when the prior federal administration and the prior president was willing to give credibility and be, a bit of a megaphone for some of those views and some of those groups. And so at least we're no longer at that point. But pushback comes in different forms. Often it will be a local law enforcement leader. Sometimes it might be, a police organization or union. Sometimes it may be leaders in the court. Sometimes it may be individuals in that new change agent's own office who are trying to push back. And I think especially when it comes from those, and most often it's individuals in law enforcement who are trying to spin out a false fear narrative. This leader, this change agent is making people less safe. I think everyone can play a part in batting down that fear narrative, in pulling up the facts that show that people are no less safe and crime is no more a threat in jurisdictions with change agents as elected prosecutors, as opposed to other parts in the country. Crime has been on a downward trajectory. And while there may have been a bit of an uptick over the course of an incredibly stressful pandemic where people were isolated and traumatized and lost their jobs and removed from support networks, that crime is still in that downward trajectory overall when you look at the past few decades. And so I think all of us can be a part of refuting those claims. And we also need to build up and lift up those law enforcement leaders who do embrace change, because they're out there and they need our support as well, so that they're not drowned out by the naysayers. And finally, at the end of the day, communities are not buying this fear narrative. We are seeing people like Kim Gardner, like Kim Foxx, like Larry Krasner, and others around the country reelected by overwhelming margins. So communities aren't buying it. And I think that does put a cap on how much we should worry about it.
I would like to add to that, because I think there's definitely an important thing to consider about who owns the narrative and how that narrative gets to the people. And, traditional media really has a responsibility in being more judicious in how they really challenge law enforcement's narrative of things. For example, we have had a situation in New York where last year, a year and a half ago, we had some really impressive reforms, including bail reform. And one of the things that the advocates and those who had worked to reform our pretrial detention infrastructure had not really considered was what would happen after, those changes were implemented. And the law enforcement community and their allies were quite adept and ready to really marshal in a narrative campaign about this notion of being less safe because individuals were no longer being held pre-trial on bail. And since that time, the legislature has responded last year with some amendments to it, and there's talk now that may happen again this year. But the force of narrative in the public space is very, very, very powerful in moving policy in our state capitol and in our city council. So I want to say that for those who stand on the opposite side of those law enforcement narratives and those law enforcement tactics, it's really important to really be prepared and willing to leverage your voice and presenting a different narrative to the public, because frankly, most people just don't know and just don't understand the dynamics of what's at play. And again, like even today, we have the issues at Rikers Island, and the forces against releasing people from those conditions are arguing public safety, when the vast majority of those who are held pretrial detention are cycled in and out of our local jails in a matter of weeks and sometimes days. So if public safety really is an issue, even with the adjudication of cases resulting in people's almost immediate release, that is not addressing the issues of public safety. And I would argue public safety isn't the issue at play, it's something bigger, and it's racialized, and we got to acknowledge that. So I think prosecutors need to be courageous and stand up to law enforcement. And I have been arguing for some time about this notion of prosecutors as the chief law enforcement agents in their communities and their jurisdiction. First of all, that narrative ties them to law enforcement. So when quote unquote progressive prosecutors come into office and try to do something different, it appears to have created a schism in that relationship. Prosecutors and law enforcement are two different entities and should be seen as such. And as long as prosecutors continue to align themselves with law enforcement, it becomes more difficult to really change the way the system operates if law enforcement is not on board.
Thank you so much for making that excellent point, Wes. We unfortunately have come to the end of our discussion, and I'm going to need to turn it back over to Monica. Before I do want to say very quickly, though, in terms of your point, Wes, about prosecutors need to be courageous. They do. And I want to point out that some of the more courageous ones are getting the kickback. They're getting pushback, not just from the police unions, but sometimes from people within their own offices. None have gotten more pushback, and I have to say this, than the Black women chief prosecutors, Kim Foxx, Kim Gardner, especially, Rachel Rollins, Dinah Becton, and so many others. And what we need to do, I mean, they have gotten racial attacks, nooses sent to them in the mail. Kim Foxx had the Proud Boys marching outside of her office. Kim Gardner has been threatened physically. People need to know this because they're out there trying to do the right thing. So it's important for communities to stand up and to support them. As Miriam said, the community did speak and re-elect them, but they need that support. When they're doing the right thing, they need support. When they aren't, they should be voted out, because it's all about democracy, right? We need to raise your voices to a point that Wes made earlier. So I hope people will step away from this and keep that in mind. And thank you so much for giving us this opportunity. Thanks to Kai, to Wes for your wonderful discussion. Thanks to Miriam, and thanks to NACDL. And now I'm going to turn it back over to Monica.
Thank you so much, Professor Davis. And yes, thanks to Akai and Wesley for just joining and engaging in this discussion. Again, this has been a part of kind of an ongoing series that NACDL has been hosting on race and different issues in the criminal legal system. And I want to give a little bit of time to one of our diversity committee co-chairs, as this is an issue and a topic that intersects with their work as well, the issues of racial disparities in our criminal legal system. So Justin, if you're still on, you can come on camera and just give a few words in terms of what the committee is and what they're working on as well. And then if you can kick it back to me, and I will close this out.
Yeah, thank you so much, Monica. And thank you so much to all the panelists. That discussion is truly the best kind of work that we're doing as an organization. And I think it enlightens all of us so much. The diversity committee is trying to have NACDL live up to its mission. Gabriel's also here. Gabriel Reyes is another co-chair from down in Texas. And we're trying to live up to NACDL's mission to be a leader in curbing systemic racism and in also helping the membership of the criminal defense bar become more united, more diverse, and more anti-racist. And to that end, we held an event a few weeks ago in Chicago at Fred Hampton's assassination site and ended up speaking with members of the community that had been present at the time of the assassination and speaking with Ida B. Wells Barnett's great-grandson, and are trying to host events in each of the cities that NACDL is in, invite young law students, invite attorneys, and then Zoom those out also to public defenders and start to do anti-racist training in NACDL. And so what we're asking you guys to consider is, how do we support and amplify you, everybody that's here? And I'll put my contact information into the chat here. And then also, how can you help us out? We'd be happy to have everybody be a member of the diversity committee and also, help us with both these events, the trainings that are already going on, and help push the work that Monica and Bonnie are doing so well. So feel free to reach out to me about the events. Let us know what we could be doing better. And then also know that we would love to have you play a significant role in the committee as well.